The following BLTV program is brought to you by O'Flaherty Law. Please enjoy.
Welcome to Learn About Law. My name is Kevin O'Flaherty from O'Flaherty Law, and today we're going to talk about how to keep your house and cars in a Chapter 7 bankruptcy. So in a Chapter 7 bankruptcy, the way that works is typically all of your debts are wiped out, but the bankruptcy trustee, who is a lawyer in charge of managing the bankruptcy for the benefit of your creditors, will take a look at all of the assets you have, and if they're over and above certain exemption amounts, the trustee will collect those assets and basically sell them, liquidate them, and use the proceeds over and above the exemption amounts to pay off as much of your debts as the trustee can. And any debts that can't be paid from your assets are wiped out at the conclusion of the bankruptcy. Now, almost always, you don't file for a Chapter 7 bankruptcy unless you have assets below the exemption amount. So it's very rare that the trustee is going to actually go and collect your assets in order to pay off your creditors, because if you're at the point of filing bankruptcy, typically your asset levels are low enough that you don't have significant assets to pay off creditors. But a question we get a lot is how you can go about filing for bankruptcy and keep your residence, keep your vehicles, because you need a place to live, you need a way to get to work. And usually you can keep both your residence and your vehicles. So we're going to explain how exemptions work and the different exemptions for vehicles and residences, and how reaffirmation agreements work. And those are basically the main buzzwords you need to know in understanding how houses and cars work in bankruptcy. So let's start by talking about exemptions. An exemption is the amount of equity you can have in a particular asset and ensure that that asset isn't taken in the bankruptcy. So, for example, if you have $15,000 or less of equity in your house, then the first $15,000 of equity in your house is exempt from collection by the trustee and distribution to creditors. If you're married and filing jointly, this raises to $30,000 in equity. And what equity is, most people know this, but just to quickly review, equity is the market value of the home minus any mortgages you have on the property. So if you have a home that's worth $100,000 and a $75,000 mortgage on it, then you've got $25,000 of equity in the home. So a couple moving parts here. One is that if you have a situation where you have $25,000 in equity in the home and you've only got a $15,000 exemption, then in theory, the trustee could sell the home and you keep the first $15,000 that are the proceeds of the sale, and the creditors get the $10,000 that are over and above that exemption that were part of that were your equity in the home. So, $75,000 is going to go to pay off the loan. You keep $15,000, $10,000 is going to go to pay off your creditors. But it doesn't usually work like that in practice, because when you have to go about collecting assets, selling them, the trustee has to get paid as an attorney for his or her time, and that's expensive. The realtors have to be paid. There's closing costs. So there's a bunch of expenses that go into selling a home that are going to have to come out before the creditors see anything. So if the amount of your equity in the home is close to the exemption amount, usually within about $10,000, the trustee is usually not going to bother to try to sell it, because it's not worth going through all that effort to have everything, all of the amount that could be paid to creditors consumed in closing costs. The other thing to understand is that when we're calculating the value of the property, that's not set in stone. So on your schedules, you can basically use any reasonable method to determine what the value of the property is, and different websites like Zillow or other ways to determine value might set it at different levels. So you can kind of go with the lowest reasonable value when you're trying to establish, basically trying to establish low equity in order to have it fall within the exemption amount to keep your home. So basically the bottom line is, even if you've got equity over $15,000 if you're an individual, or over $30,000 if you're a married couple, you should talk to an attorney, because it may be in that zone where the trustee is not going to bother to go after it. even if the trustee does want to go after it, usually they'll give you the opportunity to come up with outside funds from family or friends or however you want to do it to keep the home and buy out the amount that would go to creditors. So if the trustee determines that after closing costs, $5,000 would go to pay off creditors, the trustee will usually give you the option, rather than going through the whole process of foreclosing on the home, give you the option to come up with $5,000 to settle with the trustee, keep your home, and then that $5,000 will go to creditors without going through the whole rigmarole of selling the home. So that's how exemptions work. There's a $15,000 an individual in your home. There's $30,000 as a couple. For vehicles, it works exactly the same way. There's a $2,400 exemption per person in a vehicle, and that can be spread out among multiple vehicles. And again, if you're filing as a married couple, that's doubled. The other thing to note is there's something called a wild card exemption, and this is a $4,000 exemption that you can apply to any property. So let's talk about this in the context of vehicles. So say you have a car and it's worth $6,000. Well, let's say your equity in it is $6,000. So you own it free and clear, and its value on the market is $6,000. Well, you've only got a $2,400 exemption because you're filing jointly. But if you apply your $4,000 wild card exemption to that vehicle, and it can only be applied to one piece of property in your bankruptcy. I mean, it can be distributed, but it can only be applied once. So you can apply $2,000 to one piece of property, $2,000 to another. But this particular vehicle we're talking about, $6,000 value, you can add your wild card exemption to your vehicle exemption to bring your exemption amount up to $6,400, which is more than you have in equity in the vehicle, which will ensure that you keep the vehicle. So we've got three major exemptions in play. It's the exemption on your residence of $15,000. There's the exemption on a vehicle that's $2,400, and there's the wild card exemption. And your attorney will help you apply these to make sure you keep as much of your property as possible. So that's step one. Step two is signing a reaffirmation agreement with the company that owns any loans on the property. So this might be your car loan, and it might be your mortgage on your home. And a reaffirmation agreement is basically just an agreement saying that we're not going to wipe out this loan in the bankruptcy. So most companies that give loans are happy to sign reaffirmation agreements. We rarely see anybody refuse to do it. And it's just an agreement saying that even though all of my debts in theory should be wiped out in the bankruptcy, me and the banker agreeing that this particular loan isn't going to be wiped out. Therefore, I'm going to get to keep my house, and I'm just going to keep making payments on that loan as I did before the bankruptcy started. So if you have property within the exemption amounts and you sign a reaffirmation agreement, then you should be able to keep your house and cars. The only other wrinkle is if your property is underwater. So if the value of your real estate is well below the amount of loans on the real estate, then the court will sometimes not let you keep it because it's not in your best interest to reaffirm that loan. It's in your best interest to wipe out the property. We don't see this a lot, especially with residences, and especially since we've kind of gotten through the financial crisis. But you kind of want the equity that you have in your home to be in the sweet spot between $0 of equity and around $15,000 to $20,000 if you're an individual. If you've got negative equity in your home, that could be problematic. But you can talk to an attorney to figure out how to work that out. If you have any questions, please leave them in our comments section. If you'd like to schedule a free consultation, give us a call at 630-324-6666. And please subscribe to our iTunes, YouTube, and SoundCloud stations. Thanks so much for listening.
Thanks so much for watching our video. If you have any questions, feel free to comment below. Click the subscribe button for new videos every week, and download and review us on iTunes. Visit learn-about-law.com for other legal-related articles and videos. Visit our business podcast and video blog, seizeyourbusiness.com, and visit Making Real Estate Fun for real estate videos and podcasts. Call us at 630-324-6666 for a free consultation.
Do you have too much stuff? Is your dorm, apartment, or house too full and you don't want to sell, give away, or throw out anything? If so, Hobson Storage can help. We have over 10 different sized units to meet your needs. Our climate-controlled units are safe, secure, and conveniently located within the western suburbs. Call us now at 630-964-4047 to find out how you can get 15% off an upper-level unit, 2 months of free rent, or use of our van to help you move in. Call us and use promo code A1V as in Victor to take back control of your space with Hobson Storage.